So thanks everybody for coming. My name's Melissa Garcia, and I'm a partner over at Hyman Sanchez. What we do is we represent homeowners associations, and we give these classes throughout Colorado to all the different cities, and we try to provide basic training as well as targeted training for specific things. So get on our website. You'll see on the material at the very end, you'll see our website address, and you can get on there. We also have some flyers back there with some of our educational events throughout the year. There's also a ton of resources on our website as well that you can get free checklists and samples and all those kinds of things, webinars, articles. So whether you're here because of a covenant enforcement issue or because of a collection issue or whatever it is, an assessment issue, I mean, these are the things that that's all we do, is we represent homeowners associations. So tonight, I love to teach, and this is something that I do throughout the year, and I love seeing a great big class like this. I can tell you all you want to know about the law, but I love to hear from you too, because when I'm teaching, I'm also learning from you. And I like to hear the stories, and I like to hear the interplay. If you have specific questions as we go throughout this, please go ahead and move forward and ask your question. Raise your hand, ask your question, because I'd like to try to take it. I know it's a bigger class, so we're going to have to go through the material quickly, but I will also stay afterwards to answer any questions that you might have too. So let's go. Well, first of all, who here is on the board of directors of their HOA? Okay. Who here is on the architectural review committee of their HOA? Okay. Anyone here on the board for less than a year? Okay, I'll try not to scare you away, because there is a lot of stuff that often when I teach this class, it's like your eyes are open, like, oh my gosh, I have to think about all these things when I'm making decisions. But it really is something that you need to understand your role and understand that this is, once you accepted that nomination, unless of course you're one of the few or maybe one of the many, during the annual meeting you went to the bathroom and you came out and you were president, right? I mean, that happens. That's happened to me. I mean, I've sat there and I hear it happen all the time. I'm like, if they didn't accept the nomination, you can't make the president. So, I mean, this is something that, but once you do accept that and get on the board, you're going to have duties that you owe to the associations. That's what we're going to talk about tonight. Anybody here from the media? That also happened to me once, and that was not a pleasant thing. So, okay, so let's go ahead and get started. And Thomas is going to act as my Vanna, and I don't have to move my slides for me. So really quickly, I just want to go over what is a community association, because this is something that when you get on the board of directors, you might have a specific agenda. There's nothing wrong with that. But you put on a lot of roles as well. So you get on the board, and you may get on the board for one reason, but you end up having to do a lot of other things. So first of all, it's a nonprofit corporation. Don't forget that. I think a lot of board members forget. Once they get on the board, they're not just there to enforce the covenants. They're also there to handle a lot of money. You're running a business. You're running a business of a homeowners association. So take that role seriously. Why I put the nonprofit corporation is because you are a nonprofit corporation. You're a corporation subject to corporate law. It's a specific law, which we'll talk about in a second here. But it is corporate law. So you're not kind of moving around with just your bylaws, just your governing documents. There's also a statutory framework that covers this as well. And again, it's a business. It's a community, which means that, it's not just enforcing the covenants, but it's also remembering that you have to have your finger on the pulse of what the homeowners want. Once you're a homeowner, usually if you're on the board, most documents require you to be a homeowner. So once you get on the board, though, you have to take off your homeowner hat, and you have to put on your board hat, but you also have to know what's going on with the community. Because even though you might make these decisions that you think are great, there's a whole bunch of other people out there that are not sitting in that boardroom with you thinking the same thing. And then finally, a neighborhood. The only reason why I put that up there is because at the end of the day, it's your neighbors that you're going to be enforcing against, and sometimes that becomes difficult. Sometimes you have to make difficult decisions. And if you're a new board member, it's often a surprise of how difficult it can be. nice little old lady, Mrs. Smith over here, always brings you cookies, but she's delinquent for the last 3 years. She hasn't paid her assessments. You always want to work with somebody, but on the other hand, if it gets to a point where it's unreasonable, everybody else is saying, what are you doing? We need to treat everybody the same. So even though you need to be reasonable, you also have to treat everybody the same. So it could be these diametrically opposed concepts. So it's hard, and sometimes I tell people, maybe it's not something that you want to be on the board because you're not sleeping at night. You have these decisions. So, next slide. So what does the board do? Before we go to that, so for those who've been on the board for quite some time, how do you know what to do? Actually, whoever wants to answer this. How do you know what you're supposed to do as a board? Just throw it out. People tell you. Oh, that's the first time I've actually had somebody answer that. That's true. People do tell you. You do this, this, and this. But aside from people telling you what your role is, where would you look for this?
Governing documents.
Governing documents, bylaws. We're going to talk about those. But just remember, I think that you may have lived in a number of associations. All the documents are different. So be very careful and look at your documents, because those prescribe your authority, and you shouldn't step outside of that authority unless there's some other authority that gives you that right, such as a statutory authority. So you look at your governing documents, but essentially this is what you do in a nutshell. And it's very, very broadly stated. Manage finances, but that doesn't just mean spend the money prudently. It also means collect the assessments, know how to levy special assessments, know when it's appropriate to file a lien, know how to get a reserve fund, make sure that it's adequately funded, all of those things. Maintain the common elements. What are the common elements? What does that mean?
Everybody.
Parks, stuff that, areas, right, areas that everybody uses, right? Sort of the common ground. And so it's when you get on the board, one of the things that you need to do is make sure that you're maintaining and preserving those assets, and that means the common areas as well. Because people are going to be looking at it and saying, why aren't you maintaining the grass the way it's supposed to be maintained? And maybe as a board, because we have no money and we need to raise money. Well, we are going to do it. It's just phased in. So just remember that's a big. There's a lot of disputes that come over maintenance of common elements and the standards that you have to adhere to. But anyway, that's one of them. Provide services. That's all directed from your governing documents. Snow removal, whatever else that you might do, maintenance of whatever it is, or maybe specific services to specific units. That's in your documents. Overseas managing agent. Who here is managed by a management company? Okay, so your management company, they pretty much do everything, right? They're supposed to, right? Okay, sorry. They're supposed to. But what sometimes comes up is this blur, not sometimes, often, is this blur between what the management company does and what the board does, and who makes the decisions. That's a big deal when it comes to litigation issues sometimes, because they're thinking, well, the management company does everything, but no. Remember, the management company is the administrative arm of the board. All they're supposed to do is administer the decisions of the board. Yes, they may do these little things on their own that you've prescribed to them in their contracts that they don't have to get board approval for, but in general, the buck stops at you. The buck stops at the board. So if something's not going right, and it's not you because you're making your decisions correctly maybe, and the manager is maybe not administering it, or maybe you were not clear in what was expected, or maybe your contract didn't say what it should say. That's where I find that the devil is in the details. If you want a manager to have these expectations, you need to be clear about those expectations in the contract. And if you're not, then it's sort of like, well, they have their own expectations. And then finally, you enforce your governing documents. So go ahead and move to the next slide. The governing documents, again, is very key to a lot of what the board's authority is. And so I wanted to, before we move on to the actual fiduciary duty part, the board decisions, is go through and discuss governing documents and how they work. And this is particularly important for the newer board members. So the way it's shown here is what I call the hierarchy of enforcement. The hierarchy enforcement of authority. And why it's a hierarchy is because to the extent that there's anything inconsistent between and among these documents, the higher one is always going to control. Anybody here have documents that are over 15 years old? Okay, so oftentimes I see some of the older documents, even the new ones, have a lot of provisions that are inconsistent. And then you're like, well, what am I supposed to follow? Now you have this key. Because you might have something, for example, and this I find many times. The Articles of Incorporation, third one down, say, you shall be run by a board of 3 members. Then the bylaws, underneath it, say, you shall be run by a board of 3 to 7 members. Articles are going to trump every time. So just remember, because it's higher, well, we'll talk about each of the documents here in a second. But just remember, they're all enforceable, but to the extent of any inconsistency, the higher one's going to control. Okay. I'll go through each one of these.
Question.
Oh, yeah.
So are the covenants,
Go back.
are the covenants all of these put together or just certain parts?
All of it together.
Okay, so the whole
package.
is
And we're going to go into each one of those documents and explain them as well. Okay. Okay, so remember on the first one was statutes? Statutes, there's a lot of statutes that may apply, but the 2 most important ones that you absolutely have to know, and particularly if you're new on the board, these are the ones that govern all community associations in Colorado with very few exceptions. And you need to know these because, especially if you have documents that are over 15, 20 years old, these trump your documents. So you may be following this set of bylaws that you thought was great, and you thought you're doing a great job as a board, then all of a sudden you find out that those documents are actually illegal, or 20% of them. And so you're doing things incorrectly per law, because the law comes in and says, we don't like how homeowners associations have been doing X, Y, and Z, so we're going to enact a new law that's going to supersede your documents. So again, I keep going back to 15 to 20 years because over the last 15 years, the legislature has focused quite heavily on homeowners associations, and they have, almost every year there's been something where they've superseded particular provisions. For example, I'll give you one example. How many of you know, so when you're having an annual meeting, you send a notice to all the homeowners, right? You mail out your notice. Did you know that you're also supposed to physically post that notice somewhere in your community, at least 24 hours prior? Good. A lot of people don't know that. How many know that you can no longer enforce any covenant that requires you to have a certain amount of sod on your property? And there's a lot of them up north where they say at least 50% have to use sod, or 25%. That's no longer enforceable. And these are little nuances that I'm giving you here that, this might be news to you, but this was law 5 years ago. So these things come in and they trump, so you need to be up to date with the laws. So I put Colorado Common Interest Ownership Act first, because that's the most important statute of the 2. And that, again, governs almost 95% of the associations. And I put 2 distinctions, pre-Kiowa and post-Kiowa. Who can tell me what pre-Kiowa means? Does anybody know? I'm not going to look over there.
You were formed before Kiowa was adopted in 1992.
So if you were formed before July 1st, 1992, that's good. Okay.
Hello? Oh, okay. Okay, so if you were formed before July 1st, 1992, is this worse or is this better? Okay. Then you're a pre-Kiowa association, which means that only some of Kiowa is applicable to you. So you're kind of lucky in that way. Because there's a lot of additional requirements for post-Kiowa communities, which are the ones that were formed on or after July 1st, 1992. If you were formed as a post-Kiowa community, then all of Kiowa is applicable. So just write this down really quick. I'm not going to go over it, but the statute in Kiowa, the provision that tells you which provisions of Kiowa are applicable to pre-Kiowa associations is 38-33.3-117. And so that's the list of pre-Kiowa provisions. For post-Kiowa, all of Kiowa is applicable. Okay? And so the other one is a nonprofit code. That is more of a backup, and it's more operational, but there's still a lot of stuff in there. For example, one of the newest laws in the nonprofit code is a law that specifies the procedures for boards to take action via email. Now, how many of you regularly take action via email? And don't be shy, because that's actually more common than not. Now, there's a specific procedure per that nonprofit code that you're supposed to follow, unless your documents specify otherwise. And most documents specify otherwise for pre-Kiowa associations. Most of them say, and if you haven't seen this, you need to look in your bylaws, most of them say that to take action outside of a meeting, you need to have unanimous board approval. So check your bylaws, because if you've been making all these decisions without unanimous board approval and you actually have that in your bylaws, then there's an issue. Okay. Yes.
Cannot pre-Kiowa communities elect to follow the post-Kiowa?
The question was, can pre-Kiowa associations elect to follow post-Kiowa? Yes, they can. Okay, per Kiowa, there is a procedure where you can actually elect and choose to be post-Kiowa. So that is possible.
Is that for 100% one way or the other?
No, I think it's 67%. I don't remember the exact percentage.
No, I mean
Oh.
that you either go along with the
Right.
Iowa or not.
If you follow the procedure, then you become an entire post-Kiowa, so all of post-Kiowa. Instead of doing that, if you like some of the provisions in Kiowa, but you don't want to be a post-Kiowa community, you can certainly just amend and to include some of those provisions. You don't have to elect the entire statute. So the map, real quickly, just if you haven't looked at your map, every association is formed with a map, and if you haven't looked at it, get a copy. It's from your clerk and recorder's office, and it's recorded at the same time as the declaration. And the reason why I say that it's important to get it is because it often identifies helps in maintenance responsibilities. If you are in an association and you're wondering, well, gosh, who maintains that perimeter fence? We don't have anything in our documents that says who maintains this fence. Oftentimes a map, you pull the map, it says the association maintains the fence. Or what if it says something like, you want to know who maintains the balconies? And the declaration only says that the association maintains limited common elements, but you don't know whether the balconies are limited common elements. Oftentimes the map will say, these are limited common elements. So that's the second place that you want to look if you can't find it in your documents itself. But just get a copy for your files if you don't have one. Okay. Declaration, now that's the most important document for the association. And you'll see on that statute or that hierarchy map that it's the same as the map because it's seen as the same document as the map. So the declaration and the map are seen as the same document because they were recorded in conjunction with each other in developing the community. But the declaration is important because it includes all the rights and obligations of the association. So these are where your use restrictions are. These are where you can use your land a certain way. These are where your assessment rights are. These are where your maintenance and insurance provisions are. And the thing is, and again, it's recorded with the clerk and recorder's office. The thing is, even if you have never read your declaration, because you got this when you purchased your home, you should have. And it's also called the CC&Rs, also called the covenants. But even if you've never read it, the courts are going to say you have constructive notice of it. So it doesn't matter if somebody comes up to you and says, I had no idea that you could levy a special assessment against me. If it's in the declaration, you can. And it doesn't matter that they didn't read it. Or I had no idea that I had to submit an architectural review form before I built this 6-foot fence. But if it's in the declaration, then they're going to be deemed to have read it. Okay? So these are a couple of other things that the declaration covers. All right, so the Articles of Incorporation. That one, it's in the middle of the hierarchy, but realize this is still important because it brings the corporation to existence. And I think one of the things, so all it is it just is 4 or 5 pages. And if you haven't read your Articles of Incorporation, you can go onto the Secretary of State's office, and you just search, corporations and search your association's name, and it'll come up, and you can get a copy of your articles. But it's important for you to know what's in there because, again, there's sometimes inconsistencies with the bylaws, and the articles are going to trump. And the one I often see is number of board members. The other thing that you need to know as well is it's filed with the Secretary of State's office, and what they do every year is they send you a report asking you to say, yes, we are still a corporation, and yes, this is our agent for purposes of notifications. But if you don't respond to that report, and you don't respond for 5 years in a row, they will administratively dissolve you. And that has happened many times. So how do you know whether you're responding to this or not? They will send this periodic report to the registered agent of your association. Now, most of the time, the registered agent is your management company or your attorney. But if you don't know, you need to find out. And if you're not managed by a management company, it's oftentimes a board member, maybe the president. But the presidents and board members, they overturn all the time. They turn over all the time. So if one guy moves away and then he forgets to change that, that designation, then 5 years could go by, and then all of a sudden you're administratively dissolved. That's important because while you're administratively dissolved, your right to collect assessments, your right to file liens, your right to enforce covenants, it's all suspended. And you can't enforce that. The other thing too is your name is up for grabs. Maybe you love the name of your association. During the time that you're dissolved, anyone else can come in and file a new document and say, now we are that association. So it's key that you check that. If you don't know anything about what I'm talking about, ask your management company, and if you're not managed, then get on the website and check it and see if it says dissolved or if it says suspended. To get out of suspended, you just have to pay a fee. But hopefully no one's taken your name, because that has happened a couple times as well. All right, so bylaws. The bylaws is actually the most, even though it's 4th down on that hierarchy, it's actually the most important document for the board. And the reason why I say this is because it's the one document where I see the board consistently violate because they don't know what's in their bylaws. They don't know the specific little nuances. I've seen bylaws that say the annual meeting shall be held on March 3rd at 7 p.m. under the council tree when the moon is full. I mean, that's specific. If you have something that specific in your bylaws, you need to follow it. And what happens, what do you think? What happens if you don't? You think there's a Kiowa cop that comes along and finds you? There is not, but I will tell you, over the last maybe 10, 15 years, for whatever reason, there's been a lot, there's been more litigation filed against associations and against board members, and it's often because somebody's challenging a particular decision, they don't like a particular decision. And so what happens is, they sue the individual board member or the entire board. And they say this board is breaching its fiduciary duty, which I'm going to talk about here in a second. It's breaching its fiduciary duty because it's not even following its own governing documents. Now, one technical violation, probably not a big deal. Cumulatively, if you're not crossing your T's or dotting your I's with all your decisions and with all your procedures, then yes, that could lead to a valid claim for breach of fiduciary duty because you're not doing your own due diligence. You're not even reading your own governing documents. So the bylaws, again, is the most important document for the board because of all these nuances in it. So it contains the governance procedures, things like, it's the operational Bible of the board. Things like running meetings, what kind of notice that you have to give, how to elect directors. So for election of directors, one thing that has changed over the last couple of years is how you can conduct elections. If you have, and this is per statute now, if you have a contested board election, and that just means more people are running than positions that are open. That probably never happens, right? It's nobody is running for the board. But if you do have a contested board election, then you need to hold that election by secret written ballot. That is something that came into law a few years ago. And so what was that? Okay. Okay. So, and another thing, maybe, let me think of another one. Oh, yeah. Ballots, whether they're the secret ballots or any kind of ballots, now have to be counted by a neutral third party. What does that mean? They don't really say what that means, but they do give some clarification. It can't be somebody running for the board. It can't be a current board member. It has to be somebody that's objective. So somebody from the audience, somebody, one of the other homeowners. You can pick 2 or 3 homeowners and have them all counted. But it has to be a neutral third party. I would say it shouldn't be your management company because they have an interest on who's serving on the board. I would say it shouldn't be your attorney because also we have an interest of who's serving on the board. Just try to pick somebody from the audience who's not serving, who's not running or serving on the board. Wait, actually go back one.
Question there.
Oh, yes.
On the, if your covenants say that you're supposed to have your meeting in September, but you've had them in March, April, May.
Every other month except September?
Yeah, well, how do you get yourself into compliance on that?
Okay, that's a good question. So you have something that you clearly are not following, or you didn't even know that you weren't following, but you don't want to follow. What do? You start to follow it, or what else can you do? Change the bylaws. And that is something that, again, if you have an association that's over 15, 20 years old, it's a good time right now to start looking at your documents to see, you know, what's not in compliance with Colorado law, what doesn't make sense or reflect what we've been doing. And that's not just procedural stuff. That could be things like, well, gosh, the association has always maintained the balconies. And then all of a sudden you find out it's the homeowner that's supposed to maintain the balconies. What do you do then? You've set up this expectation that the association is saving for this and budgeting for it. Then all of a sudden you say, oh, sorry, we found out our documents said this. Now we're going to turn it over to you. You can do that, and legally you would be okay moving forward. But one thing that a lot of associations do is they actually step back and say, we're going to amend to reflect our practice and keep expectations with the homeowners. So there's a lot of things that you got to think about, but amend is probably the best thing to do. Revise your bylaws, and
until you do that, would it be where you
until you do that, you now that you're on notice of it, you follow it.
So if you so you should let the board exist for more than 1 year so that you can get to your September date? If you
Yes, you wouldn't necessarily have to then change it right then and there. I think that you can wait until September. There's nothing that's you've been acting that way for the last 10 years, and it's, well, I'm trying to think of that word then. It's in good faith. It's in good faith. You've been acting in good faith. Once you're on notice, then you're no longer acting in good faith. You have to put a plan in place. And that plan is, it's fine to say, and next annual meeting, which will be in September, we're going to start holding them in September from that time forward. That is fine. Yes?
I just have one question on, does the board have the, I guess you'd have to look at bylaws, but does the board have the ability to amend the bylaw?
I'll go into that really quickly, but do you mind if I don't use this? Can you hear me okay?
Yes.
Okay, good, because this is, I feel
Really funny, like, come on down, or something.
all right. So,
Drop the mic.
I should drop it, yeah. What was the question? Oh, amend the bylaws, right? So this is key to that pre and post Kiowa distinction. If you're a pre-Kiowa association, then the board can amend the bylaws without homeowner approval except for quorum and unless the bylaws expressly prohibit the board from amending the bylaws. If you're pre-Kiowa. If you're post-Kiowa, same thing, except that the board can amend can't amend for quorum, powers and duties of the board, or terms and qualifications of the board. So it's pre-Kiowa, you have a lot more authority to do it. Post-Kiowa, it's limited. Okay. All right, so requirements for membership in meetings, voting rights we talked about, and then the general powers and duties. Remember I talked about what do you need to look at to see what you're allowed to do? Look in the bylaws, that's where it usually spells it all out. Here is your authority, here are all the things that you are allowed to do. And other than that, that's your scope of authority. The only other place that you can look at for additional authority is the statute, is Kiowa, which has its own default list of provisions that it says, regardless of whether your governing documents are silent on this, you also have the right to do this, this, and this. So just look at your bylaws and look at the powers and duties. Okay. Rules and regulations. Rules and regulations. So, well, actually, let's go back. Those covenants, the declaration, the most important document for the association. Who gets to amend those? Who gets to revise the covenants?
Owners.
Owners. Only owners. And it's key for that because sometimes you'll have covenants that say that the board can amend it. They can't. Statutorily, only owners can amend the covenants because, again, it's the document that affects your use rights on your land. And so only homeowners can change what they agreed when they purchased the home. Opposite from that is rules and regulations. Who adopts the rules and regulations? The board. Who here actually has a set of rules and regulations? Not very many. Okay, so let me talk about what they are. So the rules and regulations, those are additional restrictions that are more clarifications of what's already in your covenants. So for example, your covenants might say you can have a reasonable number of household pets. Your rules and regulations, which are adopted by the board, can say a reasonable number means 3. Household pets means dog, cat, bird. So they're defining and clarifying and supplementing through the rules and regulations, but they're never allowed to be contrary to the covenants. And here's something that I often see boards do, is they will adopt these rules and regulations which will actually be contrary to the covenants. And the covenants might say you can have a reasonable number of dogs, and then the rules will say no dogs allowed. So again, the covenants are on the top and the rules are on the bottom. And the reason why the rules, they're on the bottom, and the reason why they're on the bottom is because the board gets to adopt them. So if they're challenged, courts are going to scrutinize them very heavily. That's different from the covenants. If somebody challenges something in the covenants or the declaration, courts are going to assume it's valid because it's written and it's recorded. They're going to assume it unless it's adopted arbitrarily or capriciously. But for rules, they're not going to assume that at all. They're going to say, is it reasonable? Is it fair? Did people have notice of it? Is it too broad? Is it ambiguous? They're going to go through all of these tests to see if the board did a good job in adopting those rules. But that's on the bottom, and they can't contradict anything. They typically define or establish behavior, or they clarify things or establish behavior. Okay. Policies and procedures. Who in here knows about the SB 100, the 9 good governance policies? You should all be raising your hands. Okay, so these policies, this came into law in 2006, guys. So 2006, the legislature said that homeowners association boards of directors have to adopt, it used to be 7 policies and now it's 9. There were 7 policies, and then they added 2 more over the years. But these are the names of them. And what they're intended to do is, again, clarify something that's already in your covenants. Certain actions by the board and the association that the legislature has deemed important enough to provide more notice and more clarification to the homeowners. So for example, and I highlighted the 2 most important ones, because these are the ones, even if you don't have all 9 of them, and you're just getting started now, these are the 2 you want in place. Collections. A collection policy You could have somebody that has been delinquent for the last 3 years and is not paying any of their assessments or any of the late fees or any of the interest. And you get to court, and the court says, well, where's your collection policy? And you say, we don't have one. You lost right then and there. Because they're going to say you have to have a collection policy in order to collect any assessments, delinquent assessments. And what this policy does is it provides clear notice to the homeowners of each step of the process. If you're late 30 days, then you're going to get a late fee. If you're late 60 days, interest is going to start. If you're late 90 days, then all of a sudden they're going to file lien and turn it over to the attorney. When do we get a payment plan? When does the association get to foreclose? All of these things are required to be put into your collection policy. And if you don't have one, then you can't enforce on your assessments. Yes, sir.
How much in detail does the state determine these policies? Can you make a policy that's 4 words long? Or
For some
are you
of them,
dictated to have a certain...
That's a great question. So how much regulation over what the policy says? The statute is pretty specific for collections, pretty specific for enforcement. On the other ones, it's a little, and you could have something that says, for example, alternative dispute resolution. Our alternative dispute resolution policy says that we as an association will attempt to resolve things by using alternative methods of dispute resolution. And that could be enough. But not so for collection, not so for enforcement. It's pretty specific on what needs to be contained, particularly collections. The other one is enforcement, and we have a whole class that talks about enforcement of covenants and the policy itself. And that one is really more about if you are going to fine somebody, then you need to establish the due process steps that take place before you levy that fine. Things like you sent a notice to the homeowners and they didn't respond, or you sent it to them and you specified exactly what they were doing wrong and exactly what they needed to do to comply. And they wanted a hearing. So, I mean, these are the things that you're going to have to give them an opportunity for a hearing. But those two are the most important. The statute also goes into a little bit of detail for inspection of records and conduct of meetings, but the rest of it, not so much.
How important is inspection of records?
I think it's really important today because as a whole, I mean, the legislature is clear about a principle that they're really pushing is transparency. And so the inspection of records policy, I think it's important not just to lay out what homeowners are entitled to know, but all of these policies are important to establish more of a regimented attitude for the boards. Because the boards, what you need to do is treat everybody the same way. And if you have these policies that say, here are the steps that you follow, then everybody will be treated the same way. And you shouldn't vary from that. So I think it helps both the board and the homeowners. But records policy is important because, if you don't follow your policy, first of all, you have to adopt the policy. Then you actually have to follow it. I have boards that just kind of adopt it and they shelve it. And then they do whatever they want. You're going to lose, That happens all the time. Yeah.
I was on our board and then life got busy, did that a couple years ago for a year, and then I just got back on. What I'm finding is our HOA doesn't really have a policy on our architectural committee. There's not a set. Would this fall under this?
So the
landscaping or the committees would come up.
Gotcha. So the question is whether or not the architectural review, whether that should be, or any kind of landscaping review, those kinds of things, there should be a policy for that. Now that's not a required one under statute. I do think it's highly recommended to have a policy that establishes how things are received, how they're reviewed, and how they're responded to in all of architectural review kinds of requests. A lot of the governing documents, the covenants, will have a good set of those procedures, but some of them say nothing at all. Even if you don't have a policy in place for architectural review or for any other committees, you should still have some kind of charter that says, here's what the committee does, and here's their scope of responsibility.
What is adoption?
Adoption, I know this is crazy, but they require a policy on how to adopt policies, okay? So it's a policy on how to adopt policies, rules, and regulations. I make fun of it because it sounds funny, but really it's a good thing, because when you're adopting these or when you're changing these, again, you want to be transparent, and again, you want to let homeowners review and provide feedback before you actually adopt the things. You don't want to work in a vacuum, and I think a lot of boards do that, not through any intention of the board, but because nobody shows up at the meetings. Do you have people come to your board meetings? Most don't, you know? And I think that the problem with that is, again, once you get on the board, there's this invisible wall that kind of comes up between you and the homeowners, and 2 days ago you were a homeowner on this side, and all of a sudden now you're on this side, there's this wall, and break down that wall and try to get people to come to your meetings, because I do think that it helps in minimizing the possibility of disputes or issues, because when they don't come to the meetings, and then all of a sudden you've been taking the last 3-4 months doing all your due diligence to make a great decision on a special assessment that is absolutely necessary, but all they're seeing is you just slapped a big special assessment on me, and they're not seeing everything that led up to it, all the due diligence, that if they came to the meetings, they would see what you're going through in order to do that. So, yeah. Okay. Oh, one more, yeah. And then we'll move on.
The term policies is not limited to the SB 100 policies.
Correct.
We've got all these, some of them are called rules, some of them are called regulations, policies.
Well, the rules and regulations and policies are all on the same line for enforcement. Remember on that hierarchy and we're on the bottom. But the rules and regulations are different from policies. The rules and regulations really define and clarify and supplement the restrictions, and they define behavior. The policies are just a memorialization of how the board is going to act in a certain context. And not just the board, but the association. I'm not being too eloquent on that, but it's more of a statement of action. That's what the policies are. So when we're going to collect assessments, this is what we're going to do. When we are going to conduct our meetings, this is what we're going to do. So instead of rules and regs.
Well, we're in the process of reviewing our documents. Should we go back and change all these old rules?
I think you should, and I think you should hire me to do that for you. Yeah, I mean, if you are in the process of doing that, you absolutely should. How old are they, your current policies?
Some of the policies go back a few years, some of them go back 10 years.
Yeah, I'd say probably because there's been changes in the law in the last 5 years that might affect those policies. So I would absolutely go through them as well.
I'm not worried that they're legal. I'm just wondering what to call them.
Okay. Well, yeah.
Should be our management company is saying you need to get rid of the word policies.
Okay.
Except
Let's talk offline. Let's talk offline for that because there's a lot more to go through tonight.
Okay.
But we'll talk after the class.
Okay.
And one more back there, then we'll move on. Did you have something? Are you good?
About policies, we have some that are 10+ years old.
Okay, yeah, they're probably outdated. I would probably have somebody review it. Okay. So the next half of the class really is about you as a board and how you can protect yourself and the association from liability through your decision-making process. And so the first thing that I want to Sorry. So the first thing that I want to make sure that you understand is, remember I mentioned fiduciary duty? Fiduciary duty is what you owe as a board member to the association, not to your fellow board members, not to the other homeowners, but to the association. Now, what is a fiduciary duty? Can anybody tell me that? What does that mean?
The utmost duty of care imposed by law.
The utmost duty of care. That sounds really good. Yeah. So, utmost duty. What it is, it's really an elevated duty. It's a position of trust, right? You got elected onto the board because people trusted you to spend their money wisely, to make sure you're enforcing the covenants, to make sure that you are preserving and maintaining the assets, to make sure you're governing the community appropriately. So it's a position of trust, like doctor-patient, like attorney-client. I mean, this is what you're entrusted with, the association's governance. So as a fiduciary, you have a number of things that you need, a number of standards of care that you have to follow. And I'm going to talk about 2 of them in detail, and then the other 2 I just want to mention really quickly. So, duty of obedience, all that means is you obey the governing documents, obey the statute, okay? Because, again, look at your documents. If you haven't read them and you've just kind of been going along with the prior boards or the prior management company and you haven't read them yourself, you need to read them because they might be mistaken. They might just be treating them like any other association, but that's not the case. And so you don't want to get yourself into trouble because you're not following your own documents. And then duty of confidentiality, that really means as a board, you should keep information confidential if it's supposed to be confidential. And sometimes we have the situation where you get on the board because you have a particular agenda. And again, there's nothing wrong with that. I mean, how many people here got on the board because of a specific reason, a very directed reason? Anybody? You want to admit to? Yeah? I mean, you stayed on the board for that specific reason, right? Yeah, I mean, there's nothing wrong with saying, I got on the board because I thought the prior board was doing a terrible job and I want to know where my money was being spent. Or I got on the board because I knew that there was a big decision coming down about whether or not to do X, Y, and Z, and I wanted to have, be very close to that decision-making process to make sure my assessments are being spent the right way. There's nothing wrong with that. But, I mean, it's information that you get while you're on the board that should be confidential until it's disclosed. And sometimes we get the situation where I like to call them a rogue board member that comes on, and then all of a sudden it's getting into these executive sessions. Everybody know what an executive session is? That's a closed meeting. You are allowed to have closed meetings. They get into the closed meeting, they get information, and all of a sudden they're leaking it out to the rest of the community. There's something wrong with that, because that's breaking down the system of how this works. It's supposed to be confidential for a reason, and it's to make sure that the association, is protected. And if you think that you're doing the right job by getting on and then leaking information, you actually might be shooting yourself in the foot, because then all of a sudden a decision can come down and you're on the board while the decision is being made and you're acting contrary to this duty, and then all of a sudden somebody sues the board. Guess who's not going to protect you? That D&O policy that you have is probably not going to protect you because you're willfully disclosing confidential information. So if you really think that the board is doing a bad job, rather than getting on the board secretively and then leaking information to try to overturn a decision, get other people on the board. Remove that board. If you think the board's doing a bad job, get other people on the board and remove the current board versus trying to sabotage the decisions of the association. Okay, so duty of care. Let's go ahead and move to the next step. So this is the most important topic that we want to talk about tonight. Excuse me 1 second. So the duty of care is the standard by which all decisions of the board, all actions of the board are reviewed against this standard when those decisions are challenged. So if you do something like levy a special assessment and somebody challenges your decision, and somebody decides to take you to court because of that decision, they're going to look at this standard to see whether or not you did that decision correctly. And I'm going to go through each of these terms specifically so you can understand them. So essentially, it's director shall discharge his or her duties in good faith with the best interest of the association and prudently. These 3 things was what a court is going to look at. Okay, so in good faith, that's just a legal term. It really just means not in bad faith. Don't do things maliciously. Don't do things willfully against somebody, wrongfully against somebody. You may have, again, let's say sweet little Mrs. Smith is coming to every board meeting, and she's providing cookies to everybody, and she's really, really nice to everybody, and you just, you know, she's as sweet as can be, and she never challenges any of your decisions, and so you let her, for example, inspection of records, you let her just forget about filling out the form and doing all the things you're supposed to do. You treat her differently. You let her do things without going through the specific channel because you like Mrs. Smith versus Mr. Smith, who is always challenging every single decision, and you're looking, all of a sudden you find that you're looking for ways to deny what he wants. And I've seen this happen where you're looking at, I see the reaction from the board when a particular person comes in. All of a sudden they settle back and they're crossing their arms like, oh God, you know? And I don't even know the board or the associations, but they have this body language that they're settling back, just waiting for him to finish so that they can deny it or reject it. You know, and that's you'd be surprised how often that happens. You need to check your own behavior if you find yourself doing that, because that means you are straying from this particular standard. So I'm going to do a little test real quick, and I just want to see who's really listening tonight. It's not really a test, but so I'm going to say a word, and for those of you who already know this, just play along. I'm going to say a word, and I want you to repeat it 10 times out loud. And then at the end of that, I'm going to ask you a question, and I want you to respond immediately, out loud. Okay? I'm going to give you a word. I'm going to ask you, you're going to repeat it 10 times. I am going to ask you a question. You're going to respond out loud. Okay? Ready? All right. Wake up, everybody. All right. The word is spot. Okay? Ready? Spot. 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 Spot, 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 spot. What do you do at a green light?
Stop.
At a green light? I myself usually go. I heard a few goes. But this is what I mean about conditioning and about you realize, you just said, the guy's saying again and again and again and again, complaining, and then all of a sudden he provides a very legitimate issue and you ignore it or you sweep it under the table. And that's not, maybe that's not malicious or, you know, in bad faith, but it still gets you into trouble because it's that guy, and it's always a guy, right? No, it's that gal that is doing this, and then you're all of a sudden just going down the same path. So what I always do, I tell my boards to pretend it's little sweet Mrs. Smith that's asking that question. Whenever you have that person, that neighborhood naysayer that's coming to these meetings, pretend it's this person instead, and then listen to the request. And maybe then you'll see it differently. Okay.
I got a question about that.
Yes.
When a board is in session, and you have, you know, neighbors, you know, at the meeting, are they
are they allowed to disrupt and to
monopolize? What I'm getting at is if they have something that is on their mind that maybe they want to change or something like that, shouldn't it be on the agenda?
Well, that's a good question. So if there is a homeowner attending a board meeting, right?
Yeah.
And they have something on their mind and they want to propose something, right?
Yeah.
So shouldn't it be on the agenda? Well, if it's supposed to be acted on tonight, that night, yes, it should be on the agenda.
Okay.
But there could be a homeowner forum where they just say, hey, what's on your mind?
Okay.
And most associations do that. And then maybe you can hear it. It's an opportunity for you to hear the concerns and say, great, thank you for bringing that. We'll consider it and we'll table it to actually decide on it at the next meeting or between meetings.
Okay.
Yeah.
In our HOA, for example, there is no avenue for the homeowners getting things on a board meeting.
Oh, on the agenda? Okay, and no avenue because they don't know when the board meetings are gonna happen, or?
They don't receive a real notice.
Okay, let's talk.
There's a posted notice that they may or may not have seen, but there is never a comment about if you want to discuss something, what is it, contact
Right, right. So first, I just want to make one point about your statement that there's no real notice that goes out. So is there supposed to be notice of board meetings going out to homeowners?
No.
Yes.
No.
I hear yes and no, yes and no.
Yeah.
So legally, there's no requirement. This is really odd. It sounds counterintuitive, but legally, there's no requirement to send out the notice the same way that you send out to the other board members. Yes, you have to get notice for homeowner meetings, but legally, there's nothing. It was in the statute, and there was a proposed change to the statute, and they pulled it out at the last minute, and I think what they were considering was costs for mailing out notice for every single board meeting. But if a homeowner wants to know when the next board meeting is going to be, you're supposed to tell them when the next board meeting is. And to be transparent, you should post notice of when those meetings are. You should put it on your website and say, come on down and observe the decision-making process. But, I think that, are you on the board now? You should probably work internally to say, let's open up this, let's create that.
We put a notice on the clubhouse door, and then we have a notice board, and we put it on the notice board.
Okay.
So but a lot of our people don't live, so they don't see the notice board, and they don't go to the clubhouse.
Do you have a website, or?
But then we're in the senior community, so a lot of them don't use computers.
So what I probably do as a board, is adopt a regular schedule of board meetings throughout the entire year. Say, we meet on the first Thursday of blah, 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 and then mail it in the beginning of the year to everybody, so they know. And it's up to them then to say, has this changed? Maybe contact the management company, has this changed or something?
But more important, there is no direction for if you want the board to discuss something, this is what you do.
And I think that internally, you can discuss that with your management company, how you can provide that avenue. All right. Next thing, in best interest of the association. That sounds easy too, but it's not. So it's in the best interest of the corporate entity. So it's not the homeowners and it's not the board. And again, you have to take off your homeowner hat, because many times these decisions that are in the best interest of the corporate entity don't align with your own best interest. But that's the hard decision you have to make when you're on the board. You should not be making decisions that benefit you to the detriment of the association. It should be in the association's best interest. So put aside your self-interests. So let me ask you a question. Let's say, who here is in a condo community? Anybody? A few of you. Okay. I usually use this as an example in all my classes, so if you've heard this before, just play along. So let's say you are in a condo community and you are on the board of directors. And you know that there's going to be a painting project throughout the community. And there's 6 buildings. And you live in building number 2. So you live in building number 2, and you as a board member know that you are going to be selling your condo unit within the next month. So lo and behold, building number 2 gets painted first. So what is that in the best interest of the association? Is there anything wrong with that?
Oh, yeah.
Smells wrong, right? Right? If you were on the other side, it smells wrong. But maybe not. I heard it maybe not. Why not?
Because it could be location or...
Could be location, right? It could be... It could... What?
They're all being painted.
They're all being painted. It could be that your contractor said this building was the building that needed to be painted first because it was in the worst shape. Maybe it could be that building number 2 was in the front of the community, so it's the one that gets seen first, and so it gets painted first. But if you are on the board and there's anything that seems like preferential treatment, again, your decisions get scrutinized, and that's what it's gonna sound like or seem like on the other side, unless you show and you demonstrate and you document that these decisions were made in the best interest of the association and not you yourself. So put aside your own self-interest. Also, put aside not necessarily best for the neighbor, like sweet Mrs. Smith, or for the loudest. I hear this happen quite a bit. There could be somebody or like a little faction that are very loud within the community. And they come in and they want a particular decision to be made, and you know it's probably not in the best interest of the association, but you go ahead and say yes because they're the loudest and they're the most dynamic, and they're always charging in saying this is what you need to do. And you don't want to waffle over those decisions, because sometimes you have to make hard decisions, and they're not always the easy ones. And they don't necessarily benefit everybody, but they benefit the association. I mean, and you shouldn't, and I see boards do this too, you shouldn't be throwing your decisions, every single decision, to the homeowners to vote on either. You accepted that nomination, you are supposed to be making decisions on behalf of the association. If you said, if you said to everybody in the community, who here wants us to raise the assessments next year? I think probably 99% of people are going to say no. But you know that you need to raise the assessments to pay your bills, to do whatever you need to do. So you need to make that decision. Here's another thing you should know as well, and this gets kind of blurred, is when does the board get to make the decision, and when do the homeowners get to make the decision? So here's the standard rule of thumb. All decisions are made by the board on behalf of the association, except for those that are specifically reserved for the homeowners to vote on in the governing documents. So what is specifically reserved for the homeowners to vote on usually? Covenant, amending the covenant. Budget. Anything else?
Sometimes.
Electing directors.
Sometimes.
Sometimes levying a special assessment. Electing directors. See, there's just a finite amount of things that the homeowners get to vote on. Because again, you're electing a board to make those decisions for you. And if the board is not doing a good job, then it's up to you to get on the board, or get somebody else on the board, or to get them in the right direction. But I would say it's a breach of the fiduciary duty of the board to keep deferring decisions to the homeowners, because that's not why you were elected. And because you don't want to make decisions based on a majority of the homeowners, even though you know and you have the information and you're reviewing all these things, that it's not in the best interest of the association. The other thing too is, again, it's not in the best interest of yourself or your neighbor, or the nicest person. And I'm going to give you one last example, and this is a real example. I call this the wind chime example. There's this really nice lady. She's a registered nurse, and she works at night and she sleeps during the day. And she lived in this patio home community. Patio homes are kind of small, close together. And so she was right next door to these wind chimes. And so she came to every meeting, and she was very supportive and always involved in all the activities and always tried to give her feedback. And a couple of times at the board meetings, she said to the board, I wish you would do something about those wind chimes because I can't sleep. And it's really bugging me and everything. And so the board goes, oh, okay. So finally, they wanted to do something nice. And they said, okay, we're going to prohibit wind chimes. Did you just drop a swab? Okay, so at the next annual meeting, they had the largest attendance of homeowners ever at this meeting. And why do you think that was? Yeah, there was close, well, maybe not that close, but almost a good 30-40% of the homeowners had wind chimes. So here's a board that didn't do its due diligence in determining whether a particular proposed action was a community-wide benefit versus just one person's benefit. And it's easy. It's really easy to do that. So you got to remember, it sounds like an easy request, but you got to do your due diligence and ask questions. And so that's actually the next slide, which is be prudent. So that's the third thing. You got act in the best interest of the association, act in good faith, and be prudent. And what be prudent means is be informed. Ask a lot of questions. Be informed before you're acting. Make sure that you're, particularly when it comes to financial decisions, the ones that there's big ticket items, those are the ones that are challenged the most. Because again, a lot of homeowners, they don't choose to go to these board meetings, so they're just thinking that you're spending all this money for no good reason. So you need to have a good paper trail showing how you came to these decisions, why it's a good decision, what was your rationale, why it's a benefit to the community, so that this isn't even an issue. And you should over-communicate that. Over-communicate that to the homeowners so that there's not even a question that's already not answered in that paper trail. So let's go ahead and look at some of these examples. We already talked about reading and being familiar with the governing documents. Go home and look at your governing documents. You'll be surprised on some of these nuances that are in your bylaws. I always talk about the bylaws. Follow requirements. Oh yeah, don't just read them, follow them. Or amend them if you don't like what they say. Amend them out. Be familiar with and follow the laws. On our website, we have Kiowa on it, Colorado Common Interest Ownership Act. You really need to look at that statute because it does supersede a number of provisions in your documents. So you need to get a copy, download it, and review it. Okay.
Question, how do you,
Yes.
probably it's higher attorney, how do you, if you've got something in your documents and you've got something in Kiowa and you're going, you know, how do these two relate, and can you depend on your management company to do that?
Oh, that's such a good question because I feel sorry for managers right now because I think a lot of associations and boards do rely on their management company, but right now the law's changed and now management companies and individual managers are required to be licensed. And one of those regulations are very clear that managers are not supposed to be practicing law. And when it comes to interpretations of things, it's a gray area of what is exactly actually practicing law versus just reading something in your documents. But to protect the management company, you really ought not to be asking your management company for legal questions. And they'll defer. They'll give you their opinion, but they'll say, look, if you want a formal legal opinion, you should talk to your attorney. Okay. Attend meetings and participate. You know, when you got on the board, you also committed yourself to go to these meetings. And if you find that you've missed maybe 2 or 3 in a row, you should resign. Because, you know, getting on the board, you should be committed to the board. And unless there's really good reasons why you're not making these meetings, we need to have a good informed board and a committed board to make really good decisions. So if it's just not in your like this lady over here said she got off because life got busy, right? Yeah, and so realize maybe it's not, even though you want to be on the board, maybe it's not a good time. But if you're not going to meetings and not participating, don't just abstain from every decision. You have to vote on things. That's, again, why you're elected to be on the board. Seek and follow advice from qualified professionals. That's a typo. Should say seek and follow advice from Melissa Garcia and Jaime Sanchez. No, but make sure that you have somebody qualified for that particular position. Don't just go to someone who's been in the business for like 2 months because they realize, wow, this is a cottage industry. Let's hang up a shingle and try to manage something because I have a little, you know, background on whatever. You need to review and make sure that the person that you're hiring knows what they're doing. So qualified decision. Don't ask. And I feel sorry for the attorneys that are on the boards because I know that the attorneys on the boards often get asked questions, and they're divorce attorneys or they're bankruptcy attorneys, which might help you in collections, but they're not HOA attorneys. And there's a lot of nuances in HOA law. Read and understand your board packet. Those of you who have management companies, you should be getting a board packet prior to your board meeting, right? Hopefully you're getting that a good, reasonable number of days prior to your board meeting. You need to read that packet before you come to the board meeting. You don't go to the board meeting and then read the board packet because the board meeting is supposed to be the time when you're actually ready to get informed and ask questions about what you've read, what you've already read, so you can actually make those decisions. Yeah?
So what's in the board packet?
Oh, well, excuse me, some management companies, I think most management companies give them things like, well, who's on the board right now? What do you get in your board packets? Financials, agenda, maybe committee reports, complaints, management reports.
Analysis of questions that came up at previous meetings.
Right. So you have hopefully a guideline of what you still need to vote on or still need to discuss. So lots of good stuff. I'm not saying that you need to go into everything in detail, but particularly, again, when it comes to something new and it's a big ticket item, you really need to review those. But just come prepared. Otherwise, you find yourself tabling things month after month after month, and all of a sudden at the end of the year, and you really haven't accomplished everything that you wanted to because you're not prepared at the meeting. Okay. Read and understand financial statements. That's, again, when it comes to money, these are the things that get challenged the most. I mean, for a while, the economy was really bad, so people were questioning every single penny. Where is my penny going? What are my assessments being paid for? How are you spending my money? So you don't necessarily, I mean, there's contracts that come along and you pay the same amount of money every month. And, you know, you don't have to necessarily review that and say, okay, that's a good bill because it's $500 every month, so you know it's going to be the same amount. But again, the big ticket items, review them in detail. Make sure that you know where the reserve funds are going. If there's something weird happening with, and you see some discrepancy, raise it at the meeting. Ask your questions. Don't just be wondering or thinking, oh, well, it's okay. It's okay. They know what they're doing. Or the president knows what they're doing. You know, we'll just say, that's fine. You know, there's only one financial document that you don't need to review in detail. You know what that is? Your legal bill. Just pay. Just pay. Okay. Attend workshops and seminars. Do what you're doing tonight. This is exactly, and I always say that I'm preaching to the choir, because if you came to this class, that means that you are interested in making sure that you're doing a good job and you're being really involved and you're trying to become informed. Try to get your other board members to come here or get to any of the legal seminars that are available throughout the state and online and all of that, just to keep abreast of the new laws and make sure that you're doing a good job. Ask a lot of questions. I'll give you another example of where somebody didn't ask any questions and they kind of got, you know, it didn't work out so well for them in the end. There was a condo building, and the top condo was leaking. There was some kind of water leak that was going into the other condos. And so it was coming down, and the board goes to the top condo and says, okay, well, there's a leak coming from your unit. And the top condo said, oh, okay, because there's a hole in the roof, and it needs to be repaired. So they said, oh, okay. So the association repaired the roof, and then they did nothing further. And then it turns out later on, months later, that it was still starting to leak again. And this was months later. So this time, which should have happened the first time, they got a contractor out there to look to see what was going on. And it turns out it wasn't from the roof, even though there was a hole in the roof. It was from a line from the unit's, I think, water heater or something. But something was amiss. And that was what was leaking into the lower units. It was actually from the unit component and not the common element roof. But in the interim, mold was occurring. And all of these things, these consequential damages that occurred because of the delay in responding to that initial water intrusion correctly. The way they didn't respond to it correctly. They just kind of assumed that, yes, it was the roof. You have to ask questions. Water intrusion ones are big ones, because if you don't deal with them correctly, they do have a lot of additional consequential damages that can occur. But just ask questions, don't just assume that it's the obvious thing in front of you. Make sure you've asked questions and you've documented it. We already talked about hiring qualified professionals. So directors, so when you're making these decisions, you don't have to, for example, like this somebody over here, I think it was you, said, you know, do you have to call an attorney? What do you do when you have a legal question? The law is not going to say, well, go out there and get a law degree and understand the law, the legal aspects of it, or go out there and be an accountant and know how every single piece of money works. The law actually says that you can rely on experts for opinions on experts. So when you have a difficult decision in front of you and you can't figure it out yourself, it's a legal question or accounting question or whatever it is, you can hire a qualified professional and rely on that expert to provide you an opinion, and just rely on that, and that's good. You know, that satisfies your duty. So you can do that with a lot of things, opinions, reports, financial statements, whatever it is, you can rely on others to do that. So if you're getting information from a committee, who uses committees here? Does anybody use committees? Okay, what kind of committee do you have?
Landscape.
Okay. Okay, good. Well, you know, if those of you who don't use committees, you should use committees, because this is great. It kind of lessens the burden on the board, and it creates more ownership throughout the community, because you have all homeowners that are involved. But landscape, maintenance. So information on maintenance issues, you rely on the committee to provide that information to you, or okay. Anybody have a budget committee?
We use the whole board.
Okay. Okay, so you use the whole board, and you have a budget committee, right? So in the budget committee, what does it do for the board?
Prepares recommendations for the budget, and also looks at the financials and has comments to the board.
Okay. So it looks at them in detail. So the committees are supposed to gather that information, review it, and then present that to the board to make an informed decision. And so the board then doesn't have to go through in detail on every single thing, and it relies on others to do that. So if you have a committee that the director believes merits confidence, then you can rely on that committee that merits confidence. And we always say merits confidence because you might have a committee that does not merit confidence, and you're continuing to rely on them. You're not going to be protected by this protection under the law if you rely on somebody that doesn't merit confidence, or experts, like I said, attorneys or accountants. So it's not good faith or prudent if the director has knowledge that makes reliance on another person unwarranted. So what that means, there's not really any kind of definition of what that means, but there could be something, whether it's faulty information that's consistently given, or maybe the information given seems to be given because it will benefit that person personally. There could be things that might not warrant confidence on that particular committee member or that particular expert. So if that is something that happens, then again, it's not in good faith if you rely on that particular committee. That usually doesn't happen. You usually should be able to rely on that expert and that information and be protected in your decisions. So business judgment rule. That standard of care that we just went through, in good faith, prudently, and in the best interest of the association, it's incorporated in this concept called the business judgment rule, which is that you as board members have the right to make business decisions in good faith, prudently, and in the best interest of the association, and you will be protected from liability if you make those decisions according to that standard. Okay. So a director will not be liable to the association or members for any action taken or omitted if taken according to the standard. So that's why it's really, really, really important for you to make sure that every decision is taken according to the standard. Because, you know, in the next slide, what's missing, the decision does not have to be right. So you could actually rely on somebody and then somebody challenges your decision anyway, and then you go to court, and the court says, sorry, association, you were wrong. But if you relied on an expert or someone you felt merited confidence, you individually will be protected from liability anyway, even if you're wrong. And this is because courts, they want to defer to your judgment as long as it's made according to that standard. They recognize that you are not experts, that you are not paid. You're not paid, right? Is anybody actually paid for being on the board? Yeah, and I always hear these chuckles, but corporate law does not prohibit you from being paid. If you were, most of your governing documents do. If you look at your bylaws, it'll say no director shall be compensated for services they provide as directors. But even if you amended that out, if you got paid, your standard of care will probably go even higher. Because now all of a sudden you're being paid for these decisions that you are making. And you are no longer protected under this business judgment rule liability theory because you're now an expert. So you don't want to be paid. Yes?
Melissa, we're in a situation where we're transferring or moving from a declarant-controlled association to homeowner-controlled. And so the declarant still controls the board. My understanding is the declarant-controlled board has a higher requirement of duty. So for those of us that are not the declarants, how does this
elected? Yeah, I mean, I think you're still under. You could still make an argument that you're under the business judgment rule because you are not a declarant employee, but it's certainly not settled law. I'll just say that because if you're elected on if you're appointed on by the declarant, That's what you are right now? You're a board?
We were theoretically voted, but I think
You
in looking
went to the
at,
bathroom,
thinking and
came
looking at
out.
the bylaw, I'm not sure they can do
Okay.
that, but
All right.
anyways, go ahead.
Yeah, because, I mean, it's a very broad statement saying if you're on a declarant control board, then you're subject to a higher standard, but I think you can also make the argument that if you are not an employee and you're a homeowner appointed person, then you are appointed per statute, not because of the declarant's interests.
Right.
Does that make sense?
Yeah, okay.
So, but unfortunately, it's not very settled. Okay. Let me see where I'm at. So yeah, you have to go back one more. Yeah, decision does not have to be right. They don't want to defer. I mean, they want to defer to you. And I mean, just imagine if they don't want to chill the possible pool of people who want to serve on the board. Because if you could be held liable for every decision that you made, nobody would serve on the board. So they recognize that, which is why they have this protection in place. Okay. So how to establish compliance of that standard? Lots of things we already talked about. Paper trail, minutes, correspondence, having those opinion letters that are in your file. Go ahead.
What about email?
You go back. Okay, that's it. I thought there was more. But it's really paper trail. Okay.
What about email as far as this list?
Yes, email can certainly be something that you can use to establish that you made an informed decision. So email, really quickly, we already talked about the fact that if you are making decisions via email, and you need to look at your bylaws because a lot of them say that you have to have unanimous approval. The other thing, the flip side of that, or the other component of emails that people don't understand or don't know about, is what kind of emails are available for inspection. And that's under the new inspection of records law. Not every single email that goes back and forth between board members is available for inspection by homeowners. But you should draft your emails as if they were. You should write your emails in the same way as you would speak in front of a bunch of homeowners. I mean, because a lot of things can be taken out of context. You do not want to be informal or kind of become really informal in your emails, because you never know, even though this is not statutorily allowed for inspection, it could be discovered in a lawsuit. It could definitely be discovered. And so you want to make sure that you're regimented in your emails. The emails that are permitted for inspection are those emails that lead to a decision by email. That's statutorily required to be provided to homeowners if they request. And again, it's emails, the thread that leads to a decision by email. There's no clarification of when that thread starts. So again, that's why you want to be pretty regimented. If you're going to vote on whether or not to hire a landscaping contractor or something via email, then you want to put in your subject line, this email thread is for the purpose of deciding on or voting on the landscaping contractor. So everything is nice and neat and just on that topic. But all the other emails, they are not available for inspection. Yes?
In our bylaws and everything else, it doesn't mention emails. But we correspond a lot with emails. Is that requiring a unanimous consent?
Well, if you're making a decision by email, then what you need to look, because most bylaws don't mention electronic mail except unless they're newer bylaws, right? Because they don't talk about email. I see bylaws that still say telegraph on it. I have to amend that out. I'm like, telegraph. So what you need to look for is language that says action or action without a meeting. Because anything outside of a physical meeting, which could be email, is what you need to look at. And if it says that all board action without a meeting requires unanimous consent, then that means yes, unanimous consent. The other thing that you want to look for is it sometimes it says consent to corporate action. That's the other header that I see that would include emails.
And that would include just talking over the back fence too, if we all got together and decided to do something?
No, because that's a physical meeting. I mean, if you decided to do something and you all got together and it's a board, a quorum of directors got together, and wherever it wasn't a formal meeting or not a meeting, that's an actual meeting.
Okay.
even if you don't keep minutes on that meeting?
Well, then you're not doing what you're supposed to be doing. But it is what I would do in those instances. If you were, all of a sudden you got together, you weren't planning on this, and you made a decision, then at your next physical, formal meeting, ratify it. Bring that decision and ratify it.
For decisions that are made that way,
Because you need to have minutes for it.
Yeah, but so often we'll end up deciding something and then only the president will sign off on the record, if you will.
That's fine. Not all the board members need to sign off on it. You have a question?
Yeah, if you have 6 voting members and you have 5 yeses and an abstention, is that unanimous?
No, you have to have all directors. And that's to be the most prudent way of reviewing that statute, that language. And I always go the most prudent way. So I would argue unanimous and unanimous. All right, so I'll hear all the things. Okay. Next duty that I want to talk about really quickly is duty of loyalty. And that's just conflict of interest. So conflict of interest comes up more often today than it ever did before, and I think because there's so many entrepreneurs out there and there's so many businesses out there, and what happens is a board member will want the association to enter into a contract with the board member's company. So the board member might own a management company, or the board member might own a landscaping company, and they want you to enter into a contract with the association. That creates a conflict of interest because it's a financial transaction or contract between the association and the board member, or it could be the board member's spouse, or the board member's other related member of the board member, or it could be the board member, a corporate entity that the board member has interest in. So that creates the conflict of interest, and I just wanted to bring this up because there's been a change in the law here. First of all, just because there's a conflict of interest, does that make the transaction void? No. It could still be the best contract out there. So there could be these great bids, and it turns out that the board member with that company has the best bid. So what you need to do, go ahead, is it's not void as long as the conflict is disclosed. This is pretty much word for word from the statute. The conflict has to be disclosed to either the rest of the board members if it's going to be voted on at a board meeting, or to the homeowners if it's going to be voted on for whatever reason at a homeowner meeting. So it has to be disclosed. And here's the change in the law. Previously, the board member that had the conflict had to recuse him or herself from that decision. The law doesn't say that anymore. It's up to you, though, as the board, to say whether or not you want that board member to recuse him or herself from that decision. And that is to have a policy in place. Remember those 9 policies I talked about? One of them is a conflict of interest policy. And the conflict of interest policy is going to say, whenever there's a conflict of interest, the board member that has a conflict has to disclose. And then you decide as a board, when you're adopting that policy, whether or not you want that board member to recuse him or herself from that vote, which I would say yes, I think so. And also to recuse or to step out of the discussion. Now that is up to you, whether, they can disclose the conflict and then they can still stay in the meeting and continue with the discussion, but just not vote on it. Or you can say, we want them out of the discussion as well. But that should be clearly stated in your policy. Okay? The other thing too is you need to make sure that when you're making these decisions, that it clearly shows whether or not the board member abstained from the vote. So in your minutes, you say this board member had disclosed the conflict and abstained from the vote. And then whether or not they participated in the discussion. And I say also practical versus legal, because sometimes there are conflicts out there that have nothing to do with financial transactions, but there's still conflicts because there's interest in play. So for example, let's say you have a board member who lives next to somebody else who just submitted an ARC request to build a fence that's now going to block the board member's view, their perfect view. Now it's going to block that. There's no financial transaction in place there, but there is an interest of that board member to reject that particular fence. So that board member should recuse him or herself from the decision-making process when it has something that affects their interest individually. Okay. I'm going to start coughing now more because I think it's kicking in. Tips to safeguard you and your association. Go ahead. Okay, obtain broad D&O insurance. What's D&O insurance?
Directors and officers.
Has anyone ever had to file a claim? So, it's really important because it only takes one lawsuit. And it's a lot of money that could be spent just defending the claim, even though you're not going to be held liable, most likely, because it takes a lot to hold a board member liable. But you want to have a good policy in place. And that's the first thing that you should definitely talk to your manager about, whether or not you have a policy. The parties covered should not just be the directors and officers. Anybody that acts on behalf of the association, committee members, any other volunteers, should be covered, should be broadly covered. Types of claims, make sure that the policy itself covers not just monetary claims, but non-monetary claims as well, because the monetary claims are usually not the ones that are filed. They're usually not asking for money, they're asking you to overturn a decision. So if your policy doesn't kick in because it's not a monetary claim, then it's not a good policy. So make sure it covers non-monetary breach of fiduciary duty type claims. Amounts, usually what I see as standard today are like $2 million. That's what I've seen, but you would want to talk to your carrier for that. You go
Does
back
anybody
one.
have an idea what a normal cost is for?
I don't. Anybody? For policy? I have no idea.
250 from American Family and about 1,200 from Travelers.
What was that first one?
250 from American Family.
That's right. You told me that.
1,200 from Travelers, and
I know. Like,
they have different coverages, and so you really have to compare what your needs are. Most of my HOAs do the American Family because it's okay, but a couple have extras, and so they're comfortable.
I have no idea.
Is that a monthly or annual premium?
Annual.
$250 annual.
So really quickly, before we move on, indemnification is something that works in conjunction with D&O. Indemnification is a provision that should be in your bylaws. What indemnification means is defend. And you should have something in your bylaws that says the association shall indemnify the directors and officers for their actions. And that means shall defend. Because you don't want to be in the situation where, for whatever reason, you individually are sued in a lawsuit and none of the other board are sued. Sue you. They're making a point out of you. And so they sue you individually, and then all of a sudden the rest of the board decides, well, we think they're right. We're not going to file a D&O policy claim to cover your claim. So and that's happened before. And so you don't want that to happen. You want to be a mandatory indemnification saying that they shall defend you, which means they shall file a claim. Okay. So the next two slides, legal audit and an insurance audit, is something that if you have never done this before, it's a list of things that I know our firm does, other firms do as well. If you haven't had your governing documents reviewed and you're thinking, well gosh, they're 20 years old, maybe I should review them just to see if they're compliant, do that. You're in a better position afterwards to know whether you need to rewrite or not, whether you need to make any amendments. Same thing with the insurance audit, whether or not you need you're over-covered or you have gaps in your insurance coverage. Talk to your management company. They probably have somebody that can, the attorneys, or you can talk to our office, can perform that for you. Excellent. Okay, fidelity insurance. Fidelity insurance is theft. You definitely want to have this. I know that you probably never happened in your association, but it's happening more and more where there's situations where, the economy was bad, the opportunity was there, and money's being stolen and embezzled from associations. So fidelity covers it. The thing that I want to make sure that you have, well, first you should cover all of these people. And it's not up here, but you need to make sure that whatever fidelity coverage you have is not triggered by a finding of guilt. So the person that allegedly stole the money, the policy should kick in once the money was stolen, not once there's a finding of guilt. Because if it doesn't come in then, and there's no finding for whatever reason, because they don't have enough evidence, then you're out of luck. So you want to make sure that it covers, it's not triggered by that.
Yeah, I got a question on that fidelity.
Yes.
If no one on the board has access to any of the money, and the
Management company does.
property management has a fidelity, does the board need one?
Probably not, as long as it says the same thing, it covers the association. There's a specific statute in Kiowa that says, and also in the manager licensing regs, it says the managers are required to have fidelity insurance that covers all their association, unless the association has a policy that covers them. So it's one or the other. Okay. All right, workers' compensation. I always bring this up, and I know most people probably don't have employees in their association, but it's that situation where there's one gap where somebody could get hurt. Well, it's a gap in coverage that is, I understand, I'm not sure, but if there's any insurance threshold. I understand it's very cheap to get workers' compensation insurance. It's intended to address a situation where you have a contractor come onto your property, and that contractor is a sole contractor with no employees. At least that's what they say to you. And then, so you enter into the contract, so because they have no employees, they're not required to get workers' compensation insurance for themselves. So then they come onto the property, and all of a sudden they bring Cousin Joe and Cousin Ed to help as well. And Cousin Joe or Cousin Ed gets hurt on your property. Public policy is going to look not just to, the contractor, but they're going to look at the owner of the property for medical bills and damages for that guy that got injured on your property. So this is supposed to cover that. And I understand that it's pretty cheap. I don't really know what it is, but it's just, again, to cover that one little gap. Yes, ma'am?
Does the HOA need workers' comp insurance when homeowners are working as volunteers?
Not workers, well, I think homeowner associations should have workers' comp insurance no matter what. But for volunteers, I mean, that happens all the time too, and I understand that. I do think that you should have at least them have some kind of sign a volunteer waiver, like a waiver or release, saying I'm participating in this activity, but I also acknowledge that I'm going to hold you harmless for any injury that I might have. We have one of those forms available on our website. Yeah?
What about for the homeowners who take on projects for themselves without consulting boards?
Okay, onto the common area, you mean?
Yeah.
Yeah, I think that's a problem.
Yeah.
I don't think that they should be doing that, and I think that you should probably tell them to stop doing that. Are they demanding reimbursement or anything? Yeah, I mean, I would be sending them a letter saying, if anything happens, like let's say they do something, maybe it's something minor, but it could be something major that if they don't do it correctly, then has additional consequential damages. I would tell them to stop. Okay. Always comply with and understand the governing documents. I already said that. I mean, that is something that's really important. Know your governing documents, understand them, and follow them. If you don't like what they say, then go into the process for amending them and make sure that they reflect what you want there. Make informed and prudent decisions and documents. And I always say, now I know we have at least one manager in the class. It's oftentimes the boards, when they come to my class and then they read all this stuff and they go straight to the manager and say, I want this, this, and this, and this. Remember, prioritize, and there's things that you need to give them time, be reasonable with some of your objectives, and don't expect them to accomplish all this overnight. All right. Yay, we finished early, so I'm going to open it up to questions.